You are not allowed to drive. Do you understand? If I find that you pick up a new case or another third case, I'm going to go nuts on all of the bonds. I'm also going to test you 45 to 50 days from today. You're not to use marijuana at all. Do you understand? If I find that next time I test you and you test positive, it's just not going to go well for you. You understand? You've given your lawyer. There's just no more excuse. If you get your license and insurance, Mr. Jackson, I will happily take this restriction off. All I'm asking you to do is follow the law. I'm not asking you to split the atom here. Really.
And Judge, we're working on it. We have a out-of-state fine or suspension, but we cannot figure out what state it comes from at the moment. So we
Call
are working.
DPS, you know.
Because they're even
You
when they
can
run-
call DPS. Have I given you the phone number?
I don't think so, but
Hold on.
I think it's in Jacksonville.
Do you mind giving this to me? This is the number to the driver's license division for DPS. When you call, you have to call at 7 o'clock in the morning. Do not call at 8. Do not call at 9, 102, because you'll never get through. Right when the phone line's open, call them. All you have to do is ask them, what do I need to do to be able to get my license? And then they'll tell you. All right, I'm gonna have you come up here, promise to us that you're not gonna drive, then I'll get you to Victoria Center Reset. You'll get with Fleischer if your bond conditions, and after that, you're ready to go. All right, good luck. You got it. Ms. Johnson, you're charged with making a false report to a police officer. You are facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. On January 19th, 2025, at approximately 1:56 p.m., the officer was dispatched to a child custody dispute at a residence in Harris County, Texas. The officer made contact with the defendant's husband, who requested a report be completed because the defendant did not meet him at a scheduled time and location. The officer made contact with the defendant at 4:45 p.m. via the phone, and the defendant was advised about the husband's request for a report. The defendant became upset and stated she was going to call the defendant's probation officer and say what she needed to say to get his probation revoked and serve 2 to 10 years in prison. The defendant stated she had video footage of the husband assaulting her last month on the phone, and she was going to call and have a deputy come to the residence to pursue charges because he completed the report. At approximately 5:37 p.m., the defendant made a family assault call, and the call slip stated, "See reportee," in reference to husband cussing and pushed reportee. The officer, who had previously contacted the defendant, arrived at the family assault call at approximately 6:02 p.m. and made contact with the defendant. The defendant stated the husband pushed her on 2 separate occasions in January 2025, and the defendant then stated the husband did not punch or push her, he merely brushed against her and admitted it was not intentional. The officer asked to see the video the defendant stated she had. The defendant denied making that statement, and the defendant then admitted to making the statement and stated she did not have a video, but the daughter was present. The defendant stated she did not feel pain, did not have visible injuries, and wanted to pursue charges. The defendant then attempted to change statements again, stating she never made a call for service. The officer read the call slip, and the defendant stated dispatch did not hear her correctly, and that was not what she meant to say. The defendant further denied making a statement regarding the husband's probation. The officer replayed a body-worn camera video of the defendant's statement while on the phone, and the defendant admitted she was not telling the truth.
This clip focuses on the judge strictly warning defendants about driving restrictions and bond conditions. The judge makes it clear that if they drive without a license, without an interlock device, or pick up another case, their bond will be revoked immediately. There are no more warnings. The court even provides solutions, phone numbers, instructions to call DPS early, and clear steps to fix the issue. But the message is simple: follow the law or go to jail. This clip shows how judges use bond conditions as prevention tools, not punishment.
Ma'am, I'm going to find if there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with a complaining witness in this case. Do you understand? That is the gentleman in this case. If I find that you have contact with this person, I'm going to revoke your bond. Look, I can provide you a lawyer today. You can explain your side to the lawyer, but I've got a bunch of DAs here. Anything you say, they're going to try to use it against you to prove guilt. Just don't. I will give you a lawyer. Just explain your side to the lawyer, and then they can go talk to the DAs on your behalf. But I don't want you to say something where you put your proverbial foot in your mouth, you know? Don't. Just. So what I would do is I'm going to have you sign a receipt of Victoria. I will have you then take a seat in the jury box. I'm going to find you a lawyer, and then you can explain your side to the lawyer. Okay? Let me see one thing real quick. I need you to fill an application for me, though. Do you mind? She's going to give you an application. I need you to fill it out, and then I'll have you talk to someone here momentarily. No. Ms. Prejean, you are charged with aggregate theft. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, man.
Yes, Judge. The officer met with the complainant, the Walmart asset protection employee, and the complainant stated that he reviewed store surveillance. And on September 12th, 2023, the complainant observed the defendant open the register multiple times, take cash, and place the cash into pocket, a total of $790.41. On September 13th, 2023, the officer observed the defendant conduct a fraudulent return for a total of $60.02. And on September 18th, 2023, the complainant observed another fraudulent return by the defendant for a total of $101.77. On September 20th, 2023, the complainant observed the defendant process a fraudulent return, take money from the register, and conduct a fraudulent return to obtain a gift card following the transaction for a total of $120.64. The complainant stated the defendant did not have permission to take money and desired prosecution. The officer made contact with the defendant, who admitted to stealing from the business 4 times, with each time being $200.
All right, ma'am, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to go to any Walmart for any reason. Do you understand? If I find that you go to Walmart, then I'm going to revoke your bond. I'm going to put you in jail. Did you need a lawyer, ma'am? Okay, I'll appoint you one today. I'm going to have you sign a receipt, Victoria, then we'll have you take a seat in the jury box while we find.
In this section, a woman is charged with making a false report during a child custody dispute in Harris County. She first claims assault, says she has video proof, then changes her story multiple times. Body camera footage proves she lied. The judge warns her not to contact a complaining witness and advises her to stop talking before she makes things worse. This clip highlights how emotional decisions and dishonesty can quickly turn into criminal charges, and how everything said on record can be used in court.
You were charged with assault. You were facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you, man.
Yes, Judge. On January 20th, 2025, the officer arrived at the complainant's apartment due to a disturbance call, and the complainant asked the defendant to leave her apartment after a verbal argument. The child was present, and the defendant then pushed the complainant, leading to further argument. The complainant landed at least one with her right hand, which were also holding a pair of keys. The keys scratched the complainant's face, leaving red marks. The complainant then held the defendant on the floor to stop her from punching her until she calmed down, at which time the defendant proceeded to spit in the complainant's face. The complainant then let the defendant up and told her to leave. The complainant stated her pain level was about a 3 out of 10, and the officer observed the complainant to have 2 red scratches on her cheek.
Is the complaining witness to Ms. Price, please?
Your Honor, the complaining witnesses are mother, the grandchild, mother of her grandson.
Ms. Price, I'm going to find that there's probable cause to go forward with your case, and I'm ordering you not to have contact with this person. I'm also ordering you not to be in possession of weapons as well. Did you need a lawyer today? Okay, I'll appoint you a lawyer. For now, I'll have you sign a receipt. Victoria will have you take your seat in the jury box. Do not leave until you sign our bond conditions, then I'll have you speak to the lawyer here. Okay, please. Okay, ma'am, you're charged with driving while intoxicated. Second offense. You are facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you.
Yes, Judge. On January 20th, 2025, the officer, a certified DRE, was dispatched to the scene of a wreck at a parking lot in Harris County, Texas. The defendant had been refused entry to a bar at the location due to appearing visibly drunk by the staff. A witness stated the defendant was not walking straight and had a hard time standing. The officer observed the defendant trying to back up from the scene of the wreck when he made a stop. The defendant had watery eyes, a strong odor of alcoholic beverage, and furthermore, the defendant was not making any sense when describing what had transpired to the officers. The defendant was transported to Pasadena jail, where Miranda was read and SFSTs were performed. HGN 6 out of 6. Walk and turn. The defendant took 15 steps instead of 9 and missed every heel to toe. In the one leg stand, the defendant used arms and swayed. The DIC was read and the defendant consented to breath. The results were 0.212 and 0.217.
And Ms. Tovar Martinez, I'm going to find that there's probable cause to go forward with your case. Do you see if she has a valid license, please?
I'll run it right now.
I am now placing a restriction on your license, ma'am. You are not allowed to drive any vehicle that doesn't have an ignition interlock on it. If I find that you drive a vehicle that doesn't have one, I'm going to revoke your bond, put you in jail. No more PR bonds. I am also ordering you not to consume alcohol or illegal drugs, and I'm going to randomly test you. If I find that you're using anything illegal, likewise, you will go to jail. No more PR bonds for you, ma'am.
Your Honor, we have no license on file.
You do not have a license, then no driving. Do you understand? You will be signing an affidavit with me today, promising you're not going to drive, and I don't care what is going on in your life. Do not drive. Since I'm ordering you not to drive, you will get a handheld interlock device that you're going to take with you everywhere you go. and where you go to prove to us that you're not consuming alcohol, man. I'm sending notice to DPS in Austin that every single officer in the state will know that if you get pulled over, you're supposed to have an interlock in your car. So if you're caught driving a vehicle that doesn't have one, they're going to put you in jail. Do you understand? Would you like a lawyer today, ma'am? Okay, so for now, what I'm going to do is I'm going to have you go to Victoria, sign a reset. You will get with Fleischer for bond conditions, and then I'll have you take a seat in the jury box while we try to find you a lawyer, ma'am. Okay. Morning, Mr. Daniels. Do you have a lawyer today?
Sorry.
You want to apply for a court-appointed lawyer?
I started working on this second. Have a lawyer next quarter.
I'm willing to give you a free one. Okay, it's up to you. If you have any problems, come back.
I just started working, so I'm saying,
Good job, man. Great. What are you doing?
delivery, so. Third parties,
Get a trade, dude. Get a trade. Go like welding or something like this.
I got my four list. It's hard finding a job. It's hard. So I knew somebody that got me in with the delivery, so.
Good.
Yeah.
You know, the better you do, the higher you're going to go. Anything in life, man. Put your heart into it. Your sky's the limit. Right. Okay. THA. All right. We got you, man.
This clip covers multiple theft cases, including Walmart and Target incidents, where surveillance footage clearly shows employees stealing cash and processing fraudulent returns. One defendant even admits to stealing several times. The judge imposes strict bond conditions, banning them from returning to those stores. The key lesson here is that surveillance and asset protection teams document everything. What may seem like small theft turns into criminal charges, possible jail time, and a permanent record.
Good luck. So, ma'am, it looks like your lawyer was involved in an accident this morning, so he's not going to be here. So what we'll do is we're going to do probable cause. After that, we'll just give you a normal reset. They called us to advise you to call the office, and then you guys can get together with them. Okay. So, ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am.
Yes.
Okay.
On January 19th, 2025, the officer was dispatched to a target in regard to a theft. The officer made contact with the complainant, a loss prevention employee, who stated she observed the defendant walking inside the store, grab a shopping cart, select numerous items, place the items inside the basket, and conceal cosmetic items, food, and office items inside her purse. The defendant headed to the register where she only paid for the items in her basket before exiting the store and passing all points of sale. The total was $111.28.
All right, Ms. Aldan, I'm going to find that there's probable cause to go forward with your case. Where is this from again?
Target.
Target. I'm ordering you as a condition of your bond. Target. Do you understand? If you violate this condition or if you pick up a new case, a warrant for your arrest will be issued. No more PR bonds, man. So can you file that, please?
Yes, sir.
I'm going to have you sign a reset. We'll have you take a seat in the jury box. I'll get your bond conditions. We'll have you sign it. And after that, you'll be free to go. Okay? So Danuna was in an accident this morning, I guess. So he's not going to be here. So we'll just do a regular reset. Just do, I guess, 30, 45 days. And then she needs state's conditions. How are you?
Good, how are you, sir?
Happy Monday.
I'm sorry, I couldn't hear you.
Happy Monday.
Oh, happy Monday.
I have one of our trial cases for tomorrow.
I believe I have one set, but I think he pled his felony.
It's Mendoza.
Yeah, I think he pled his felony. And if not, I will announce not ready, mostly because I got texted some videos last night. Well, I got emails some videos last night.
Let me pull them up real quick. Hold on.
I feel like he was dismissal if he pled the felony, and then I think they rushed the felony.
Judge, do you have the case number?
I do.
Okay.
2502-101
And 02.
and 02. Well, they reset it.
I don't see any.
219.
My
Yes.
problem is I have they all overlap, and I swear I have two reckless drivings, each of them with a gun, and one of them called my office to say he pled. I guess it might have been the other one.
Our gun case pled, but the reckless driving is still open.
Okay.
And then it looks like the felony evading in a vehicle got reset to 219.
All right. Can we hold off on that till tomorrow, Judge? Because I came in here thinking that they had pled upstairs. And I obviously got the guy confused who pled upstairs. So let me make some phone calls. Because the client called me to say that he had pled. And I thought it was this one.
What are they doing upstairs? Is there any news?
We're in touch with defense upstairs and they are going to take, the defendant is going to take the deferred and felony and then dismiss our cases, adding the condition about the firearm, I believe.
Yeah,
Are they doing a
gonna-
TRAS? Is that why they did the reset? Are they doing a TRAS upstairs? Is that why they did the reset? Because a lot of times prior to a plea, they'll do a TRAS.
We reset from the last setting without actually agreeing to plea. Kelsey then sent out the email, hey, will you do it? They agreed to plea. I thought my client called me to tell me that he had done the plea. I think he has now agreed.
Did they do the
to
plea maybe? And they
plea.
just set it for to do a TRAS?
They hadn't officially done it yet, sir, but I'm talking to the felony defense counsel, and we were hoping you could just come do it tomorrow when this one's set for trial, but we wouldn't actually be going on it because that was the agreement.
This final clip shows both strict punishment and opportunity. A second DWI defendant with a very high breath test result, .212/.217, is ordered not to drive, not to drink, and must use a handheld interlock device everywhere. Another defendant charged with family assault receives deferred probation, a second chance, but only if he completes a long 18-week BIP program, avoids alcohol, and follows every condition. The judge even offers early termination if he works hard. This clip shows the balance of the justice system. Discipline with opportunity, but only for those who take responsibility.
Bless you, wherever you are.
Is he in custody?
No, he's gone.
I'm looking at I'm just looking at
I will say, I got the cell phone video that was emailed to me yesterday, and it's not particularly reckless. Yeah, the donuts, there's a good distance between him and all the other cars. Shush.
on the reset, they didn't mark anything. And then under settings, it's just a non-trial setting.
Well, so they reset it, and then after they reset it, Kelsey, and I'll give all the credit to Kelsey, sent all the emails and got everybody to agree to take the plea. So all the paperwork was before the defendant had agreed to take the plea.
You said you want to set it for tomorrow?
No. I thought he had already taken it, and I think we're set tomorrow.
Right.
So I can have the
Want to go
client come
ahead
in
and
and
set it?
Well, I can walk him up to felony court, except for the fact that I'm not his felony lawyer, so I can't take the plea.
I'm not asking you to do that.
No, what I was saying is I
Set
can
it
normally do
after
that.
the felony.
Oh, yes, please. But I would say leave it for tomorrow, because I don't want to communicate with the client. Like, if he's not set tomorrow, I might not be able to get a hold of him, and he might come in anyway. So if we leave it
We don't
tomorrow,
have-
he comes in, I say hello, and then I set it for the day after the felony.
So what if he doesn't show?
Tomorrow? Oh, top 10 of beans?
So I revoke it?
I would hope not, but that's a conversation I'll reserve for tomorrow.
I mean, what's, okay.
Yeah. You're thinking two steps ahead, but like kind of in a lateral direction as well.
Have to.
I know, but right now we have a resolution, it's plotted out, we're gonna get this resolved.
With you.
I'm choosing to think positive. Also, I'm trying to suck up to this one because I need a time served offer on a different case.
Okay.
All right, thank you, Judge.
Morning, Mr. Harris. Mr. Harris, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. You guys have worked out an agreement where they're offering you a 15-month deferred. This is a type of probation that if you successfully complete it, you do not end up with a conviction on your record. What you must understand, though, is there is an affirmative finding of family violence in this case, meaning that you ever pick up another one of these cases, you will be facing a third-degree felony, minimum of 2 years, maximum of 10 years in prison. Do you understand? For you to complete this successfully, you must do a batter's intervention prevention program, a BIP class. This is tough because this class is you must do it once a week for 18 weeks. And if you fail to go 1 week, they're going to kick you out. You get kicked out. We issue a warrant for your arrest. I'm going to put you in jail. I'm going to bring you back out. You're facing up to a year in jail. Do you understand? It's no joke. No alcohol, no drugs. You must do also what's called a TRAS, an evaluation, to see what other conditions you may need. If they assess other conditions, you have to fulfill them as well. Do you understand? Weapons, no. Harassing, threatening, abusive contact with Brittany Senegal and Chanel Clayton. Mr. Harris, I will make you a deal. If you get this done quickly, I will take you off in half the time. If you're nice to everybody, get your classes done quick, sign up. As soon as you start getting this thing, I'll take you off in half the time. You can be done in this thing 7.5 to 8 months if you really kick butt. be nice to everybody and just don't test positive. Do you understand? Like I said, if you violate this thing, I'm going to issue a warrant for your arrest. You're looking at a year in jail. You give up a lot of rights by entering this agreement. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this, you're stuck with this until you complete it or you get revoked. You understand?